Hey, Attorney Brian Parker here, saying hello. It's time for another exciting video. This is, as I always say, it's going to be an unusual one. I've decided I'm going to take a case of a client that I represent from the beginning to the end, whatever that end is. Hopefully, I feel strongly it's going to be positive, and I'm going to show you why. So when I first brought this to your attention, I was showing you how just maddening it was, how bad the lawsuit against my client was botched. So we went to court, we had a pre-trial, and the judge said, there's no proof that, let's say my client, Ms. Smith, even owes this, the assignments are all whacked out. So they amended. So let me just put up their amended lawsuit. I'll just put 2 pages, a couple of pages. Shazam. That is a good indication of, they went from a 4-paragraph lawsuit. I'll put that up very quickly, their original lawsuit, Shazam. And let's put all 3 pages next to each other. And you can see they went into greater detail. But as I always say, when you make them push back, they come back with the worst stuff, whether it's sending a validation request or, in this case, an amendment. I've done amendment. I may have sent it on this case when I gave you the amendment video. There goes the amendment video right there. Anyway, so this is the next stage. We had a pretrial, as pretrials do. A pretrial conference is where the court sets the litigation dates. When are the witness lists due? When the expert witness lists due? When is discovery over? And of course, when's that summary disposition going to be filed? I'm filing one. So that's how strongly this I feel and how strong this case is. So the reason I show you their lawsuit, they amended. And their amended lawsuit, I filed an affidavit. And let me put up, I'll put up the first 2 pages of the affidavit. Shazam. And I want you to not quickly, but just look at that and see how that is written. It isn't just, we didn't do it, so therefore we didn't do it. It's, here's why. And here's take a pleading that they said. And here's what they're alleging. And then I have my client, and I work with her, respond to this. That's how I want your affidavits to look, as I've said 1,000 times before. Why? Because again, it follows you through the entirety of the case. Case in point is today's video, which is how to create discovery against a plaintiff debt collector. And because of that affidavit, as I said, it always follows you in every event of the lawsuit, that counter affidavit. So you've seen our affidavit. That affidavit went into our answer. And I will show you a couple of pages, just a couple. The first 3 pages of my answer. Shazam. Just check it out. First of all, I've got my preliminary statement. No rule requires that in the answer. Parker's rule. Put in a prelim so you can ADH this. So if someone doesn't have much tension to your lawsuit, boom, hit him on the front, exactly what this case is about and why you should win. And then you'll see how I'm laying down. If you go to page 2, I'm talking about the original creditor not being the original creditor. I've got some stuff in there from WebBank. You know, whenever you see WebBank, start counting the money, because they're just, it's all about pretzel litigation. And WebBank pumps out these deals. No debt collector in his right mind should take these cases. But they go on the assumption that 90% of cases they take and file will be defaulted anyway. If you look at page 3, in paragraph 4 of their complaint, for example, they said that WebBank and Upgrade are federal savings banks and or trust corporation lenders doing business in the state of Michigan. So I just went on the website, put it right on page 3, and just Googled. It says, is Upgrade a bank? And Upgrade says, we're not a bank. We're a financial technology company. So you get little nuggets like that go directly against the attorney who is using pretzel litigation to try and twist and turn into the paperwork they've been given, because it's all been securitized and tranched out and messed. And now these guys have got to get it put together and say, wink, wink, we own the debt. Well, wink, wink, no, you don't. So what I do is, now I've told you, I've got the affidavit for you. And now what we do is we take the affidavit, we put it into our answer, as you saw with the answer. And the next stage after the pretrial conference is the discovery. So discovery is your right to discover the case against you, and it's called discovery. It's probably got other names. But what I will do is show you again the first 2 pages, and this is in my show notes. By the way, everything I'm about to show you, Word templates, show notes, whatever it is, will be on my membership website. So you'll have your templates to make your discovery requests. Makes it easier for you to conform to your state rules and of course your facts. But what I'm doing is showing you what I do with the facts. So let's put the first page of the amended complaint. And right off the bat, they're helping me out. Now comes plaintiff and original creditor, Wilmington Savings Fund Society, FSB, as owner trustee for Upgrade Inc. So Wilmington Savings Fund Society is nowhere to be found in the paperwork. They've already failed in they're calling Wilmington a owner or original creditor or a lender. Impossible. In fact, if you look at the caption, look at their name. That's not several plaintiffs, that's one plaintiff. So, and they call themselves plaintiff and original creditor. How? Who knows? Wilmington Savings Fund Society, FSB, as owner trustee for Upgrade Inc., as servicer and web bank. There's so much, that should be 3 or maybe 4 plaintiffs. Let's say they won and someone's got to cut them a check. Who do you write it to? You can't. There's no bank account drawn on this conglomeration of many entities. But this is what you get, and you sometimes go, there's no way I'm looking at this. This is what they do. And if you look at number 2, paragraph 2, the named plaintiff includes all the entities identified as original creditors. So now they're saying there's more than one original creditor. How's that possible? You can just go to the Truth in Lending statement, Shazam, and there's the lender. In other words, original creditor, it's, hey, there's your friend. It's web bank. So there are no original creditors, and it certainly isn't one of the plaintiffs so far. This Wilmington Savings Fund Society, FSB, has started to pop up with no ownership proof in any cases I've seen, and certainly not this one. So what I did is just use their documents against them. Have you heard that before? So I took their lawsuit, and for my first request for reduction, I'll put it up, my first request for production of documents. Please produce every document showing how Wilmington Savings Fund, FSB, is the original creditor. You're just asking to say and prove what they said. They're not lying, are they? And then number 2, please provide a specific assignments or transfer document showing the transfer, sale, or assignment of any rights, title, or interest in the specific loan here from the lender web bank, because to Wilmington Savings Fund. So what are you doing? You're going, all right, if they're original creditors or if they even have an ownership interest, show me. And you're going to get pushback. You're going to go, here's a document with and they may even have an actual pretzel taped to the piece of paper, trying to say what they can't say. That is where your motions to compel come from. And then as that motion to compel video as a means to stop a summary judgment tells you, you'll get a court order early on saying, no, you got to show the assignment. In fact, there goes the video for motion to compel to stop a summary judgment. check that out. And you just go all in on their own paperwork. Look at my first interrogatory. Where specifically does the loan agreement attached, and they say Exhibit A is the loan agreement, mention Wilmington Savings Fund Society, FSB, as an original creditor? It isn't there, but you got to either get them saying it doesn't or it does, and so you back that up with, now show me the paperwork, which I'm going to tell you how they're going to respond. They're going to go, just trust us. It's sort of there, read between the lines. Don't accept any of that. And I'm not being, this isn't in a small exception. They all do this because securitization is really screwing over the debt collector. I'm not on their side, but because it benefits you. We just got to get more people fighting back with these. Again, my interrogatory number 2, Shazam, says, okay, you say you're Federal Savings Bank or Trust Corporation lenders. I write specifically, please state specifically which entities in paragraph 4 are Federal Savings Bank and which are Trust Corporation lenders. They don't know, and they just use flowery language. In the caption on interrogatory number 4, Shazam, I state in my notes, what proof do you possess that Wilmington Savings Fund Society is an owner trustee for Upgrade? If you see their caption, they're claiming to be an owner trustee for Upgrade. I don't know if they're as owner trustee of Upgrade, because Upgrade's not an entity that needs a trustee. If it was Upgrade Trust Incorporated, doing business as something trust, then you have to have a trustee. This is so bad that sometimes you go, am I missing something? You're not. Don't question yourself. This is really bad. Wilmington Savings Fund Society, FSB, can't be an owner trustee for Upgrade Inc. as servicer. They've just added the words as servicer. And even if you look at the caption, I'm not being picky. If you're going to take my client's money, you got to have standing. And they say it also includes Web Bank. It's Web Bank. It's W-E-B, capital B-A-N-K. It's right there on the federal disclosure statement. Let me put that up there quickly. Hope it's big enough. And you can see it's Web Bank, but they separate Web and Bank and call it a funding entity. But the corporate name of Web Bank isn't with a space. So not only is there a couple of entities in one plaintiff word, they don't even get half the status, business, corporation, or name correct. I S you not. This is what schlock comes out sometimes, and they put up a big fight about it. So, so then you say, well, I say in request for production number 4, Shazam, please produce documents to show who are the original creditors and what document shows this, and who or what entity initiated, secured, and funded the loan. So they said it, so give me the documents to prove it, and they, of course, don't have it. Maybe they'll surprise me. I'm going to tell you what happens with this law firm and this company. They will produce stuff that doesn't respond to the inquiry, knowing that they can't, and hopefully you just let it go, which I won't. I want this motion to compel, okay? I'm gonna go straight to, I really poured on the work here, and I'm gonna attach to my membership website, I got about 10 interrogatories and 10 requests to produce. I don't go nuts, because remember, this is going to be a motion to compel. So that's the thing I'm going to have to counsel you on. When you file a discovery, automatically assume it's going to involve a motion to compel, because they're not going to respond. There's 2 reasons. Number 1, the attorney knows the answer but figures you'll do a motion to compel so he'll make more money. Sorry. Having to battle against that, and then they'll charge their clients for engaging you in discussing this. Then finally it'll go to a motion, they'll put up a fight, then they get to bill their clients. That's number one. Number two, they don't have the answers, and they're going to hope that the judge sees things their way. I already been in front of this judge. We're at an amended stage because she said, I just don't see how you have ownership, essentially, when she was talking to the plaintiff. So they were forced to amend, and it just got worse for them. But in a nutshell, here's interrogatory 9 and request for production number 10. If someone said to me, you can only do one interrogatory and one request to produce, it would be number 9. Please state the name of the company or entity that owns all the rights, interest, and title to the specific debt or loan. And request for production, please produce every document evidencing the name of the trust or entity or company that owns all the rights, interest, title, and specific debt or loan in this case. That is dead nuts, exactly what's in your affidavit and your answer to their lawsuit. And by the way, I also did a counterclaim against them for all this. So when they fail to answer, they support my counterclaim, which they're eventually going to seek to dismiss it because it has no proof. It's based on their proof. It's 80% at least. In this case, it's about 100%. So my biggest point to you in doing discovery is, I'm going to end this now, but my biggest point to you is you must fight on hills you're prepared to die on. So don't send 50 interrogatories or 50 boilerplate requests to produce. I did 10 and 10 of each. Specific dead nuts on my answer, on my affidavit that's carrying through. I'm asking for what I'm alleging all along is wrong with this complaint. And I've shown the court just that, how consistent I've been. But the hills that I will die on are just 10 interrogatories. And that's not done these days, where people limit the amount of interrogatories and limit the amount of requests to produce. They'll also throw in requests to admit. I don't do that. I ask for a hill I'm willing to die on. I'm happy to go to court with a straight face and say, can they just prove they own the debt and how their original credit is, when that's the basis of why they don't own the debt and why the answer will show itself. And Your Honor, they could have just answered and they failed to do that. So use my templates on my membership website, collectionstoppersolutions.com, to conform to basically the same questions. When you get one of these lawsuits and they don't even use the word debt and they're claiming an assignment, see Exhibit A, and you go to Exhibit A and it's just a loan agreement, it's not anything what they say, dive deep. You can just change the name of the plaintiff here and use it if it conforms to your state. This word template is going to be good for you as far as doing discovery. You'll have my affidavit. I'll put it on Word so you can use it. I'll have my answer. I'll put it in Word so you can use it. You're going to have their answer, their original lawsuit and their amended lawsuit, how crappy it is. But all I did is take their paperwork. Again, I always counsel clients on video, not clients, friends, members, on videos that just use their stuff against them. There's really no work here. You've got my template. They're bringing schlock. And what I do is, you can tell, I cut and paste what they said. And then I say, explain how you both could be owners, or explain how you both could be original creditors. I just use their words against them. It's beautiful, especially you want to get to that motion to compel. And again, I've got videos on how to do motion compel. There goes one, there's one. Everything you need to just trip these guys up with their own words and documents, it's in the next step. And what I said to you is, I'm going to take this case from cradle to grave. And you've seen the first part of this is the lawsuit against us, the answer in the affidavit. Today, after the pretrial, is the next stage in the litigation, which is discovery. You don't need anything else. I am going to depose whoever it is that will say, yeah, Wilmington Bank is the original creditor. He or she is not going to say that. They're going to say everything but that. And that's another approach they'll take. They'll just worm their way around this stuff. But push with a hill you're prepared to die on? That's the questions to be asked. I hope this is helpful. Everything I've talked about will be on my membership website, collectionstoppersolutions.com. Go there. It's chock full of tons of videos. Go check it out. And templates and instructions and my show notes for every video. And by the way, there's a free PDF on there that explains how to answer a collection lawsuit by the numbers at every stage of the way. Again, I always try to give you more than most services give you. People charge hundreds of dollars for this stuff. I have one monthly fee for 130 videos that you can just have fun all day long. I think it's about 130 videos. I know at least 130 on my YouTube. But this is great value, great instruction. You got me who's done this for 30 years. I know the ins and outs. I've got lots of bruises too that you don't have to incur because I took the hit for you. So like, love, subscribe, and let's rock and roll. Let's go get these guys. Thank you.